Defamation at a Glance by Marcetta Linton, Legal Matters and Media, Full Sail University, Winter Park, Florida, February 16th, 2020. We are going to actually look at two different cases. The first one being New York Times versus Sullivan. And this case actually takes place in 1964 in the beginning stages of the civil rights movement. And this was actually a launch pad for the civil rights movement in the media. The key players in this case were L.B. Sullivan and the New York Times. This was a landmark, like I said, it was a landmark civil case. It was the launch pad for the civil rights movement. According to the Times, Sullivan was in contempt of advocating unlawful acts, breach of peace, obscenity, solicitation of legal business, and various other formal for the repression of expression that had been challenged in the Supreme Court. Libel can claim no talismanic immunity from constitutional limitations, which meant there was actually no immunity at the time for the the article being published. The Supreme Court at the time, there was no laws protecting libelous publications, which were newspapers, magazines, other publications at the time that were big. There was thus a requirement to explore more fully what constitutes libel. The word libel. The Supreme Court quickly dispensed with the primary defense, authoritative interpretations of the First Amendment, which is freedom of speech, guarantees to have consistently refused to recognize an exception for any test of the truth, whether a constitution does not protect the libelous publication, and it did not matter at the time who actually said or did. It could have been a public official or not. It was not at the time. It was not considered the part of the First Amendment. Later, the law did change, and now magazines and newspapers do have the privilege of actually stating more of a freedom, but they still have to walk a fine line. Our next case we're going to glance at is Gertz versus Walsh. This case actually happened in 1964 also, but it also had more to do with the fear in working on the fear of the public with the communism. And at the time of 1964, the United States and Russia were in a heated space race, trying to get science more, beating each other. In the space race, they were trying to get the first man on the moon. Russia had already got the first man into space. So there was a lot of paranoia with Sputnik going around. So the word communist really shook people up. It shook the public up, I should say. This case at a glance, Welsh, which was the respondent, is a magazine publisher who warned his readers that a national police force was being developed and that supported communism. The respondent ran a false article which accused Gertz, an attorney in the town, that he was the leader of this police force, the leader heading this police force up, the creation, I meant. He falsified information against the attorney Gertz that he did, in which he personally did not like. And being there was very little magazine laws at the time, this was a landmark case of actually falsifying information, which a lot of the laws from this particular case are still intact today. What was done about Gertz? There was no proof that connected him to a communist party. There was no photos. There was no documentation. There was even his electing records. There was nothing that stated he even had connections to a communist party. There was absolutely no evidence backing Walsh's claims that he posted that when he posted that Gertz was a Leninist. Did this affect Gertz's career? In my opinion, in the 1960s, the word communism was a panic. I would imagine that this probably created a big problem for him at the time, including loss of business, the community trying to drive him out, making national headlines, in which it did at the time, and it still is a pretty big case to this day. What would I have done different? If I was Walsh, I would not have let my personal feelings cloud my judgment. I would have fact-checked information before publishing the content, and if I had suspected anything, I would have gotten more evidence myself to have as proof. The defamation laws in Florida. Under the Florida law, the elements of a defamation claim to the defendant published a false statement about a plaintiff to a third party and the falsity of a statement that caused injury to the plaintiff. This means that if both cases would have been tried in the state of Florida, and both parties, including Walsh and the New York Times, would have been paying fines or maybe even seeing jail time for what they actually did. What did I learn from these cases? I would definitely fact-check all my sources, cite them out where people can find them. I would make sure I have witnesses and interviews to back me up. I would never assume anything, and I would not let my feelings cloud my judgment. I would not let my heart get in the way of telling the truth, because when that happens, it becomes an opinion. Thank you for listening. Have a great night. Defamation at a Glance by Marcetta Linton, Legal Matters in Media, Full Sail University, Winter Park, February 16th, 2020. Today we will be looking at two different cases that both showcase defamation of character. The first one being New York Times versus Sullivan. As you can see the picture below, it was the launch pad for civil rights movement in published media. The key players in this was L.B. Sullivan, who was being sued by the petitioner, the New York Times. This was a landmark civil case that was the launch pad for the civil rights movement, like I said before. According to the Times, Sullivan was in contempt and advocating unlawful acts, even breaching peace, obscenity, solicitation of legal business, and various other female for the repression of expression that would have been challenged in the Supreme Court. Libel can claim no talismanic immunity from the constitutional limitations. There was actually no form of immunity against what Sullivan did. What did the Supreme Court have to say? At the time of the case, there was no laws protecting libelous publication, and there was thus a requirement to explore more fully what constitutes libel. The Supreme Court quickly dispenses with the primary defense authoritative interpretations of the First Amendment, which, if you don't know, is freedom of speech. Guarantees have consistently refused to recognize any exception for any test of truth, whether the Constitution does not protect libelous publication. The next one actually happens during the space race, when America was kind of paranoid of what Russia was going to do. And this was between Gertz and Walsh. The case at a glance: Walsh is a magazine publisher, who warned his readers that a national police force was being developed that supported communism. The respondent ran the article, which accused Gertz, an attorney, that he was the leader of the police and he was the driving force behind it. He had no information whatsoever, no ties to what Gertz, which was the attorney, did. He falsified information against the attorney, which is Gertz, that he really just did not like. He did not like his character at all. But being the magazine laws at the time were not fully covered, it was a landmark case in the United States history for falsifying information. What was actually done about Gertz? There was no proof that connected him to the Communist Party, and this actually created stricter laws on falsifying information in the media, which is still around and is still enforced today. There was no evidence whatsoever backing Walsh's claims. There was no photos. There was no documentation. It was actually all word of mouth. Did this affect Gertz's career? In my opinion, the 1960s was all about paranoia of what Russia could do to the United States, being they launched Sputnik and they also launched the first man into space. So the public had a paranoia about communism and about the Iron Curtain and all that. I would imagine that his business was impacted and the community was even trying to drive him out. I even think that this could have made national headlines. Oh, it did. What I would have done differently: if I was Walsh, I would not have let my personal feelings cloud my judgment. I would have fact-checked my information before even considering publishing the content. And if I did suspect something, I would have gotten more evidence as proof for myself. I live in the state of Florida, and the defamation laws of Florida are as follows. Under the Florida law, the elements of a defamation claim are: the defendant published a false statement about the plaintiff to a third party, and the falsity of the statement caused injury to the plaintiff. This could be physical, this could be emotional. Either way, if both cases would have been tried in the state of Florida, both parties would have either seen jail time or they would have been paying heavy fines for what they did. what did I learn personally from these cases? I would fact check all my sources, cite them as proof. I would make sure I have witnesses and interviews to back me up at the time of the story, and I would never assume anything. I would not let my feelings cloud my judgment, and I would not let my heart get in the way of the truth. When your heart gets in the way of the truth, it takes it away from being the truth, and it makes it more of opinion / an editorial. I probably definitely would have done all those to keep me from getting in trouble. Thank you for listening. My sources are as listed. All my articles. You can find both full records of these cases on Amazon.com under the books. You can actually purchase them. And thank you for listening, and good luck. Defamation at a Glance by Marcetta Linton, Full Sail University. New York Times versus Sullivan. Who were the key players and why was it significant? Respondent L.B. Sullivan is sued for damages in a civil libel action. The petitioner was the New York Times. This was a landmark civil case that was a launchpad for the civil rights movement. Sullivan's reputation was at question for being libel. According to the Times, he was in contempt of such acts of advocating unlawful acts and even a breach of peace. There was no immunity at this time from such constitutional limitations. What did the Supreme Court have to say? At the time of the case, there was no laws protecting libelous publications. There was thus a requirement to explore more fully what constitutes libel. The Supreme Court quickly dispenses with primary defense. Authoritative interpretations of the First Amendment guarantees have consistently refused to recognize an exception for any test of truth where the Constitution does not protect libel publications. Gertz versus Walsh. The case at a glance. Welsh, the respondent, is a magazine publisher who warned his readers that a national police force was being developed that supported communism. The respondent ran an article which accused Gertz, an attorney, that he was the leader of this police force. He falsified information against the attorney that he did not like. Being the magazine laws were not fully covered at the time, which was 1964, it was a landmark case in the United States history. What was done about Gertz? There was no proof that connected him to any sort of Communist Party, and this actually created stricter laws in the United States on falsifying information. Did this affect Gertz's career? In my opinion, in the 1960s, the public had a paranoia about communism. I would imagine that such impacts to his business would include his clientele walking away and even people treating him wrong, discriminating against him, and wanting to virtually chase him out of the community he was living in. None of these were proven. He still stayed in the community and his business still thrived. What would I have done in this case? If I was Walsh, I would not have let my personal feelings cloud my judgment. I would have fact-checked my information before publishing the content, and if it was false, I would not have published it. I would have gotten some eyewitnesses that maybe seen Gertz in action in particular events that would have maybe led to him being a communist spy. I would have kept a more lookout versus just writing what was on my heart. The defamation, I live in the state of Florida, and the defamation laws of Florida are, under the Florida law, the elements of a defamation claim are the defendant published a false statement about the plaintiff to a third party, and the falsity of a statement that caused injury to the plaintiff. What did I learn from these cases? I would definitely fact-check all my sources, cite them. I would make sure I have witnesses and interviews to back my stories up. I would never assume anything. And I would not let my feelings get in the way of clouding my judgment and bettering a story. My sources come from, my articles are www.casebriefs.com/blog/law